interest group across New Zealand. The climate spokesperson has brought a case against a number of polluters, including dairy farms, etc., saying that because of the climate change caused by these actions, it's causing issues for a number of the rural communities where these indigenous communities live, and it's having real impacts in that space. And the Commission had applied to be an intervener in that case, and it went to the Supreme Court because it first got went through a system where it was tried to be struck out, and in the case where it was heard at the Supreme Court, the Commission emphasized that we're increasingly recognizing state responsibility to curb corporate human rights. It recognized the right to life under the ICCPR. It recognized that the UN Human Rights Council also recognizes climate change as one of the most serious threats. And importantly, it also recognized the right to culture, which is protected under our Bill of Rights Act, as well as the ICCPR. Based on that and a number of other things, the Supreme Court decided that the claim can proceed in terms of being heard, and that's where the story is, because we haven't yet got to the stage of an outcome. But yes, if we can make impact in terms of that international human rights jurisprudence, the Commission will take that chance.
So that is good to know, because if you look at on the face of it, discrimination looks narrow. And I think that opens up a little bit more room to play with in terms of creative application and interpretation of how you construe discrimination. So now I'd like to open the floor for questions and comments. I'm going to collect some questions. So please raise your hand, identify yourself, and try to be brief. I'm going to start this part of the room here. So we'll start with Luke and then go to the lady there. So if you can pass on the microphone, just here first, and then we will go back to that side. Anyone in this side of the room? No questions from this side? There's one there. So we'll take 3 questions. We'll go to that woman first, to her first. Second and third. We'll just follow the order. Yeah, thank you. Yes, please start.
Thank you everyone for what a really interesting discussion, and really appreciating everybody's insights and honesty. I just want to pick up on some of the comments that Shanta made. I guess questions for Shanta, but David may also want to comment, because I know you've considered NCP engagement before, but maybe gone away from it, so you might have some thoughts on this too. I wanted to pick up on Karen Adams' suggestions in the plenary this morning about NCP reform, having been through 2 NCP complaints now, both involving Peter and Cellcore in PNG. So just strongly endorse the suggestion about the power to sanction and the requirement for good officers to be compulsory. That I think is absolutely essential. And then another, insight we have is when there are findings made of breaches of guidelines, how to make this more public. So suggestions along the lines of not like simple things like making it more easily obvious on the website of the complaint, but also like having the ASX or stock markets be informed. We've often talked about the requirement of having ministerial press conferences to promote breaches of guidelines, so it actually makes the news cycle, because it doesn't make the news cycle often. So those sorts of sort of low-hanging fruits. I think our experience of the complaints, there are a couple of key challenges of the NCP, and I note we've got various independent examiners in the room, as maybe even some, as maybe, no, that's all right, I'm not going to go into specifics, it's okay. But the challenges that national contact points, plural, not just Australian, have with FPIC. Surya mentioned about rights holders. The CP communities we represent are not considered rights holders, at least according to, we haven't been successful with that. They're considered stakeholders who effectively have no rights, and that's the challenge. So the question of whether the NCP, or NCPs generally are, and the OIC guidelines are actually able to really grapple with FPIC as a challenge, given that rights holders can often be denied rights or not qualified as rights holders. And the other one is the question of making adjudications on very technical environmental questions and challenges we've seen. So not going into any of the specific complaints that we've been involved in, but just general questions about that. I think I'll leave it there.
Thank you. And I guess that will also cost money, right? Collecting evidence of, let's say, environmental pollution, technical specification, right? I believe that is also a challenge in terms of capacity of communities to find resources. I think, Peter, you were hinting to that, right? Okay, so we'll go to the, yes, please.
Hi, thanks everyone. It was great listening to your perspectives and thanks for summarising your experience, Shanta. I've also spent a long time working in PNG and Fiji, and one of the things that I've seen come up repeatedly, and it's linked to consultations, is about working out appropriate revenue sharing with communities that are impacted, involved, that's fair. And I'd be really interested in hearing from you both about what good looks like in this respect. And the other question is to the new representative from the New Zealand Human Rights Commission. I'd be really interested to get a sense of, I know in Australia the main area of complaints is around disability-based discrimination. I think that's the highest category. I'd be interested to know what the trends are coming out of New Zealand as well. Thanks.
Thank you for that. I'll take one more intervention. Let's say two more interventions. I'll come to second round as well. So let's take the question from there. Thank you.
Thank you. Thanks for such a great panel. And a question for Vani and Peter firstly about, could you speak a bit about how the corporate involvement in your communities has created division, if it's created division within the community, and what are some of the ways that you've managed to respond to that, or what have the difficulties have been on the social, the cultural level of that division that's resulted? And then for Peter and for Shanta, Australia's a pretty good jurisdiction for victims to bring claims. Discovery, compensation, damages headings can generally be pretty high. When we're talking about transnational claims for home-based Australian companies, say in the Pacific or elsewhere, what are some of the promising judicial trends, if you can speak to anything? Parent company liability in particular, but unjust enrichment or other causes of action which might be of interest. Thanks.
Thank you very much. Let me try to collect two more questions. If you can be brief, then I can capture both of you in the first round. Yes, please.
Hi, my name is Jeffrey. I'm not a lawyer by profession, but I'm here to...
That's a good sign, because access to remedy is not really about lawyers.
Yeah, I'm from Bougainville in Papua New Guinea. And I've lived through a war in the 90s, from a civil war that erupted because of mining operations and destruction to the environment. So I know how hard it is, being at the receiving end of any industry that is extractive and done in a way that is not done with mutuality, in a consultative process that respects the right of people. It gets very messy. Now, I think one of the things that Papua New Guinea and Bougainville, where I come from, we have been the recipients of colonial laws in terms of legislations where the rights to land and resources actually removed away from them. In the case of Fiji, where the ocean floor belongs to the government. Certainly in Papua New Guinea, I think we're still sort of living through that phase where legislations are still stuck, as they were before, even before the Bougainville War came about. I think in this meeting, I know there are a lot of lawyers and people who also work with the private sector. What I would like to see is maybe a little bit more accountability from the private sector. In companies, when you come into a place like Papua New Guinea, where we don't have the systems and structures, like hearing about the non-judiciary remedies, with institutions like the human rights commissions. In Papua New Guinea, those things are not transparent, those institutions. And so a lot of our people feel like we don't have anyone to go to. And it's also a sad case where the rights owners in the Frigo River have been just named as stakeholders. And the rights have not been recognized. And I think one of the solutions going into the future, and particularly in places like the Pacific, is maybe a little bit more accountability from everyone, from government, from resource developers, and I think not to just go into these places thinking about profit. And I think my appeal, being someone who grew up in a war, is that I think in this time and age we need to be more consultative. I have conversations to making sure that whatever decisions have been made does not affect the future.
So profit with principles,
Yeah.
and peace with principles. Okay, that's your message. Thank you, Unisa, if you can be brief.
Thank you. Question for David. Just with the case where I think a number of letters were sent to banks as well as investors. I just wondered if you had any examples of, without naming names if you don't want to, kind of good and bad practice when it came to engagement with those institutional investors, but then also the banks, because I remember those letters were detailed, they're based on the UNGPs, very technical in terms of the use of concepts there and just how the engagement worked with some of those groups. Thanks.
So thank you for all the reflections, comments and questions. So what I will do now is I will throw these combined questions and comments to the panelists. I'll start with Shanta, then go to David, Gail, and then I come to Peter and Bonnie at the end. And if you can be brief, I can try to take more questions. Thank you.
I'm going to try and address a few of those at the same time. So I mentioned how, and I shouldn't be talking in acronyms because I'm sure there's people in here who've never heard of the Australian National Contact Point, and I'm just going to give you a very brief rundown as to why I think it is exhibiting some of the characteristics of an effective non-judicial mechanism. So the Australian National Contact Point is the body that the Australian government has to set up under the OECD guidelines. The OECD guidelines on multinational enterprises on responsible business conduct. It is the longest name. But so one binding aspect of the OECD guidelines is that OECD adherent countries, which obviously include Australia, must set up a national contact point. So that's the only binding part about it. The rest of it is the expression by governments to business as to what governments expect business should do in order to fulfil the standards of being a responsible business. So that's it in a nutshell. And the Australian National Contact Point has a secretariat that's housed in Treasury, and it then has a number of independent examiners. I'm one of them. Aletta, who asked one of the questions, is another. John Sutherland, I think, is maybe in another session, but he's at this forum as well. And we're not employees of government. We are independent of the process. We're not representing the company, and we're not representing the complainant. So we're independent. And what happens is when the Australian National Contact Point receives a complaint, it now goes to one of these independent examiners to manage that complaint. And so it's for the independent examiner to assess, does this actually meet the requirements of the OECD guidelines in terms of being considered? So kind of an initial threshold, will it be taken further? And so it's the independent examiner who makes that assessment. We'll produce a report that's public, and if a complaint does go through, there's the offering of good officers, which is effectively a kind of mediation or mediation style attempt to get the parties to resolve the issues. If they can't resolve it, or a party decides not to participate, and that's where it gets back to one of Luke's suggestions, then what happens is that there is a final statement prepared, again by the independent examiner, who will look at all of the information that they've got and is then tasked also with potentially looking for other information. So we're not restricted to just what's been put to us. We can go and ask further questions either of the parties or of independent experts or of other NCPs. We can do our own research. So there's quite a lot that we can do in order to examine an issue and then assess whether the complaint should be upheld or not upheld or upheld in part and make recommendations where that's appropriate. Now the downside is there isn't any mechanism for enforcing it. And so suggestions such as, well, perhaps there should be, perhaps the Australian government should commit that if a company has been the subject of an adverse outcome from an OECD complaint, then they shouldn't be on a panel that might receive government contracts. And
You may not be speaking at the forum like this.
They might. I don't know if that's a punishment.
No, just a random reflection, because sometimes we give like good businesses a platform to amplify, right?
Sure.
So I'm just saying random reaction to what you were saying. I've consulted the co-organizers, but that was my spontaneous reaction.
As I say, some companies might see that as a benefit, but I do, and so it's not perfect. There are certainly things that I think could be improved.